the first basic rule is, and Jonathan alluded to this, is that within its enumerated powers, Congress can preempt states any day it wants because federal law trumps any and all state law. That's the basic order of the Supremacy Clause. And that's implicated in the dope debate, but not, I think, in a very interesting way. State laws provide or may provide a safe harbor against local prosecution under state law, but not, of course, immunity against federal law. I recognize there's an Arizona state court ruling to the opposite effect that seems to suggest the opposite, but I think that's no good and it's plainly wrong. That's the first proposition on preemption. The second proposition is that federal preemption and supremacy must take the form of a prohibition. That is to say, either a direct regulation of private conduct, don't smoke dope, or, as in true preemption cases, a direct or implied prohibition against certain forms of state conduct. That is to say, here's an example: no state shall go anywhere near the rates, routes, and services of airline carriers. That's preemption. That's a prohibition. To put this the other way around, and to put it in the terms in which the Supreme Court has put it, the federal government may not commandeer states. That is to say, it cannot compel state legislatures to enact laws. That's New York versus the United States. And it cannot compel state officers to execute federal laws. That's Prince versus United States. That's obvious here. The obvious implication with respect, or the most immediate implication with respect to the dope question is that, look, no state has to criminalize marijuana just because the feds do. And no state has to enforce federal laws or prohibitions, although state courts, of course, are still required to do so.